No way. Dude, he's got to get roasted for this argument. This is actually the most bad-faced shit I've heard in my life.
Dropbox provides an exact forensic copy of what they have.
Oh, true. Actually true. The boomers are impressing me.
File title name in this situation should have been exactly the same.
He's realizing halfway through, he's like, oh, fuck, I fucked up. Oh my God, I just fucking told a whole dumbass fucking lie in front of the judge.
Mr. Binger somehow retitled it, but the image I gave
Mr. Binger's like, hell no, Brady, you're laying under the bus on your own on this one. Did you see him shake his head over? He's like, I ain't retitled shit. I'm not going down with you on this one, motherfucker. I only make $50K a year. Watch his head, watch his head here.
Mr. Binger somehow retitled it, but the image I gave the crime lab is on my phone.
He's like, Kyle's rifle is aimed this way. And he's got one arm like up here supporting it, and then his other arm is over here with his hand like right here on the barrel. But the thing is that this is plenty of discussion surrounding Judge Schroeder's dismissal of count 6 regarding the possession of a dangerous weapon by a person under 18 in the Rittenhouse case. Was the dismissal justified or an indication of the judge's bias? Oh, so this was in response to a tweet. Just when you think the judge in the Rittenhouse trial couldn't show any more bias, he just dismissed the possession of a dangerous weapon by an individual under the age of 18 charge. As per Wisconsin law, anyone under 18 in possession of a dangerous weapon is guilty of a misdemeanor, punishable by up to 9 months in prison. Rittenhouse was 17 on the night of the shootings and would thus seem to be in direct violation. Pretty cut and dry, right? Possession of a dangerous weapon by a person under 18. In this section, dangerous weapon means any firearm, loaded or unloaded, any electric weapon as defined by this section, metallic knuckles or knuckles of any substance which should be put to the same use with or the same effect as a metallic knuckles, a nunchucka, or any similar weapon consisting of 2 sticks of wood. Damn, you can't have nunchucks? Or a manrikiki gusari, or similar length chain having weighted ends. Any person under 18 years of age who possesses or goes armed with a dangerous weapon is guilty of a Class A misdemeanor. However, Rittenhouse's lawyers drew attention to a subsection which states that the ban applies solely to minors armed with short-barreled rifles and shotguns, outlined in section 941.28. Effectively, this loophole paved the way for the dismissal of the weapons charge. Okay, this. Possession of short-barrel shotgun or short-barrel rifle. In this section, rifle means a firearm designed or redesigned, made or remade. A short-barrel weapon is a rifle having 1 or more barrels, having a length of less than 16 inches. This section applies only to a person under 18 years of age who possesses or is armed with a rifle or shotgun if the person is in violation of section 941.28. Literal D&D rule lawyering here. Although prosecutors argue that the exemption essentially swallows the statute, Judge Schroeder, after initially refusing to dismiss the charge, ultimately had them admit that Rittenhouse's AR-15 did not qualify as an illegal short-barrel rifle as described in section 941.28.
I ultimately read the statute and have, even when I ruled on the motion to dismiss, I was of the opinion that the statute was as interpreted by the defense, but there was not sufficient grounds to grant the motion to dismiss. Is the firearm here now?
Yes.
We can either measure it, or you can stipulate that it does not meet what I've stated are the requirements. And if it is out of compliance, if the barrel length is less than 16 inches, or an overall length less than 26 inches, then I'll deny the motion. If it does not meet those specifications, then this defense motion will be granted.
We are not disputing that the barrel length is appropriate.
Isn't legal?
It is not a short-barreled shotgun or a short-barreled rifle. Yes.
Either by barrel or by overall length?
Correct.
All right, and then count 6 is dismissed.
Jeez. Somebody said a TikTok video went viral relating to this statute.
So the Kyle Rittenhouse defense attorney argued that Kyle was actually allowed to be carrying that weapon because of hunting laws.
That just simply isn't true, but you're not going to know that if you don't read past the BS headline. He's using a Yahoo News story, so if you scroll down a little bit, they're pulling a quote from another news story. So click on that news story, and then you get this, which has the same BS headline. And that headline is BS because if you scroll down in their own article, they say that Rittenhouse's attorneys argued that the state laws only forbid minors to carry short-barrel rifles and shotguns, and the other prohibitions pertaining to children fall under hunting laws, meaning that the law doesn't apply to him, not that hunting laws make it legal for him to carry. And his lawyers are correct, and I've said this from the start. He's charged with violating Statute 948.60, possession of a dangerous weapon by a person under 18. His rifle falls under the definition of dangerous weapon, and any person under 18 years of age who possesses or goes armed with a dangerous weapon is guilty of that. And that seems open and shut that Kyle is guilty of that. But if you actually scroll down in that statute, see, this section only applies to a person under 18 years of age who possesses or is armed with a rifle or a shotgun if the person is in violation of 941.28. Well, what is 941.28? 941.28 is possessing a short-barreled shotgun or short-barreled rifle. Since Kyle was carrying a rifle, it's the short-barreled rifle part that would apply to him, and that is a rifle having a barrel of less than 16 inches or a rifle of having an overall...
Why do they not include long barrel rifles in the law? Probably because people are way more scared of handguns, because that's what kills people, and also probably for hunting reasons. That'd be my guess. Rip. Yeah.
Length of less than 26 inches. And the gun Kyle was carrying has a barrel length of 16 inches, which isn't less than 16 inches, and 35 inches of overall length, which isn't less than 26 inches. So Kyle wasn't violating 941.28, so this section...
What is the... Now, I don't know if this is the law technically as intended. It's hard to say. Is it called a runtime error? There's two types of errors you get in your code. Well, there's probably more than that. But like if you have a compiler error, then it just doesn't compile and you have to fix it. But then you can also have code that compiles, but it acts in ways that are unintended. Is that a runtime error? There's a lot of the law, I think, that functions like that, where you have law and it gets passed and it works, but then when it gets actually like tried out in court, you're like, oh shit, wait, there's like a weird loophole here, or there's like something that's like, fuck you.
Section doesn't apply. But is he violating 29.304 or 29.593? Well, 29.304 is restrictions on hunting and use of firearms by persons under 16 years of age. Well, first of all, Kyle wasn't hunting, and Kyle was 17, so this law doesn't apply to him at all. And 29.593 is a requirement of a certificate to get hunting approval, which Kyle wasn't doing. So because Kyle wasn't violating any of those statutes, the possession statute does not apply to Kyle. But instead of reading the article or figuring any of that out, you just wanted to read the headline so you could do this.
But it really begs the question, what exactly was Kyle Rittenhouse hunting?
He wasn't. But for some reason, you and others just want to hate this kid, and I really don't understand why.
Well.
So the Kyle Rittenhouse defense attorney argued...
Okay, sorry. Anyway. Essentially, Rittenhouse's weapons charge was dismissed on a legal technicality, a result some experts describe as the price of drafting unclear laws, and one of the prosecutors should have sought to avoid via an appeals court ruling earlier on. Okay, you gotta be really careful when you use words like this, okay? Dismissed on a legal technicality. Motherfucker, you're in court, okay? What, like, we're not here to get, you know, screamed at by mom and dad, okay? We're in court, and court has to do with the law, you know? Like, I don't like this, like, legal technicality thing inserted here. Like, I don't know, this seems kind of, eh. The fact that Rittenhouse's AR-15 was simply too big to qualify as illegal for a minor to possess may be ridiculous, but this is an indication of the inadequacy of Section 948.60, not biased on Judge Schroeder's part. In truth, Rittenhouse escaped prosecution on count 6 through sheer dumb luck. Probably true. What is the judge supposed to do? Okay, it's not against the law, but it does seem like it should be against the law, so he's guilty. Yeah, talk about, like, what do you call that, legislating from the bench when Supreme Court people do that or whatever? Unless you literally want the judge to write new law here, right? Like,
and there are allegations made there about the material that was provided to them.
Yes.
Certainly if I follow through on what you wanted, I think I warned the other day because I was queasy, very queasy about this particular exhibit of the from the drone, and we exchanged a lot of emails over the weekend about it. And I think I warned you the other day that you're putting an awful lot of emphasis on this.
yeah, it's their most important piece of evidence.
It's not technologically sound.
Uh-oh.
This is, I referred to it as the situation as a house of cards. This is just more weight on that. if I now allow them to review it without restriction as to the number of times.
Judge,
You're comfortable with that?
we are. Now, if I can respond at least to that portion of the motion to dismiss, it's factually inaccurate. So let me go back to the first Friday of trial. Mr. Lukowski was testifying. In the middle of his testimony, I got a notification that there was someone at our office who was refusing to give his name with a drone video. This drone video was shown on Fox News a couple days after the incident. It apparently was on the internet briefly and then taken down. The defendant's first attorney, Mr. Pierce, appeared on the Tucker Carlson show and discussed the video and seemingly brought the video. We've been told since then by the person who took the footage that they've sold the video to Fox News. Now, we've had a poor quality of this video the entire time. It's actually in Exhibit 41, which the defense submitted. On Friday, the individual who took the footage, who had been unable to find.
Wait. Who had the poor quality of the video? Did the defense have the poor quality, or did the prosecution have the poor quality? The defense had the poor quality. Okay. Sorry.
Came and airdropped the footage to Detective Howard. Airdropping is a way that it just goes from phone to phone. It doesn't go through text messages or email.
Okay, real quick. Also, again, guys, okay? Oh my God. There's so much tomfoolery that goes on with videos and compression and data and everything that people just don't know about. I honestly don't know about a lot of shit. Be careful when it comes to transferring. Be careful when it comes to transferring files that might determine whether or not you go to jail for 100 years or not, okay? Or your client does. Why? Jesus. I don't know. There's got to be like a secure, like FTP server or something that you can just send a bit-by-bit perfect copy of a file to. Why are you fucking airdropping? Like, bro, you got the video where he shoots the dude, right? Yeah, hold on. Let me iMessage that over to you, bro. Like, I think it's on the Discord server. Like, check it out. I threw it in the dreams, memes, and crime scenes room. Like, Jesus Christ. Use an actual fucking file exchange server. Holy shit. Even my tax accountant, even my fucking CPA guy or whatever has me, like, actually sending files to a server. There's got to be some way to fucking do this.
It has to be iPhone to iPhone. So in the middle of Mr. Lukowski's testimony, I asked...
Bro, did the defense get a copy? No, but they're fucking Android losers. The judge is like, well, you had Androids. What'd you expect?
Mr. Howard to go, and our investigator, to go speak with this individual and see what he had. I suspected it was this video from the Tucker Carlson show. It was. Detective Howard got a airdropped copy. He brought it into court. As soon as the next break happened, which I believe was just minutes after he arrived, as soon as the next break occurred, which I believe was just minutes after Detective Howard arrived, I took all three defense attorneys in the back to discuss a couple of issues which are not relevant. And I also indicated that we now had a much better quality drone video. Detective Howard asked them how they would like to receive it. Miss Wisco asked that it be emailed to her. He emailed her the file. Now, somewhere along the lines, whether it was, it appears the issue is, I believe Ms. Wisco could not have an airdrop because she has an Android phone.
There's a saying that we went from smart users in front of dumb terminals to dumb users in front of smart terminals. Damn. We're learning. There's a lot to learn about computer compression shit, boys. Your Honor, we got the recording captured in GTA 5. Now, we tried to take a picture, but we noticed from far away, for some reason, something called LOD was preventing us from making out what actually happened. And the trees all appear as blobs in the back. I don't know. It was the Android.
I believe whether it was...
Damn, dude. And again, let me reiterate for the trillionth time. I'm sorry, the trillionth time. Normally, this shit wouldn't matter. Normally, it doesn't matter. Normally, footage is grainy. Normally, it's whatever. The only reason why this is so important right now is because we're talking about like 8 fucking pixels determining the outcome of this case, right? That's like...
It appears the issue is, I believe Ms. Wisco could not have an airdrop because she has an Android phone. Going from an iPhone to a Android, it appears somehow compressed the file.
Is that from an... Do those... I'm trying to... Is there like some FAT32, like NFST or whatever, NSF, whatever the bullshit file system that makes iOS files incompatible with... No, I thought everybody formatted their disks the same way or whatever. Isn't that the case now? Aren't all disks formatted essentially the same? No, this is all bullshit. He comes out with the truth after the break? After the break. Oh, shit.
I have an Android phone, too.
We did not know.
Oh, no. He's like, wait, are you saying Android people are virgins? Is that what I heard you say? I've been using an Android for 55 years, son. I got 12 grandkids, motherfucker. How many kids do you have? iPhone punk.
That this would occur. If I
Hold on, make it
somehow compress the file.
I have an Android phone, too.
We did not know that this would occur. If I knew how to compress files and knew all this technology things, I'd have a much better job. So this file was given to us. We gave what we fully believed was the full file to Ms. Wisco. It was admitted to evidence. It was the authenticity was stipulated to. It came in without objection. We've heard many times this trial how there was no objection.
Oh, come on. But they had no idea. That's like that is a bad faith argument, right? Like, oh, like I sent him the video or whatever, and it's like, oh, bro, you couldn't tell that there were like compression artifacts due to the mismatch of file system transfer? Like, what? Come on. How the fuck are these guys supposed to know this? Are you serious? That's unironically, that is a super bad faith. They didn't object to it, right? That's some shit that you pull on like your fucking like girlfriend when you get drunk some night. You try to lie about where you are. It's like, oh, were you with any friends last night? Yeah, I was with Jack and John. Really? Yeah. What about Samantha and Jane? Okay, I was with them too. Okay, yeah, okay, and yeah, sure, also them. Like,
it was an exhibit for 4 days and played and shown to the jury and on the screen.
No way, dude. He's got to get roasted for this argument. This is actually the most bad faith shit I've heard in my life. What the fuck?
4 days. And then on Friday is when I think we all discovered that something had happened to Ms. Wisco's file. She played it on the big screen. It clearly looked different than the copy we all had. I believe we offered to airdrop it to the other attorneys, and I think it was declined because they didn't know how to use airdrop. And then we got her the full copy. We cannot be held responsible for the software on Ms. Wisco's phone. We didn't
Android destroying the case, actually.
compress anything. We didn't change anything. That would have been something that happened in the transfer that we had no knowledge of. We of course did not mean to give them a different copy, and until Friday when Ms. Wisco played it and it looked different than what we've been looking at, we had no idea.
Destiny, this is the correct argument. The defense cannot let the trial go on knowing that there is a defect with the exhibit. They must object to it timely or else they forfeit the right to it later. Yeah, but wait, aren't they just now realizing that it was defective? I don't think they knew that for the whole trial, no?
Yeah, it was any different. And then when requested, I gave her, so what I did is I took an email from Detective Howard. He emailed me the file. It was not compressed. I don't know, probably because it's Apple to Apple, or I was using Gmail at the time. It was the full.
They objected as soon as they realized their file was different. Yeah, gotcha, okay.
As far as we know, the only copy of the video we were ever given, the only copy that's ever been had, and then I put it on a thumb drive to give to the State Crime Lab. So I cannot explain why Ms. Wisco's file had been compressed. That is not something that we can be held accountable.
How the fuck did the courts not have someone who's a bit more tech literate? Yeah, and somebody in chat mentioned something too. Like, you should be using like CRC checks or something. You should be having like bit by bit perfect copies sent around to people. That, especially evidentiary stuff, that's just important. That just seems so weird to me. Well, I shouldn't say that seems weird. This is literally a small town courthouse, right? If I had to guess, a lot of these people probably still use like fax machines and shit. Like, their offices probably looks pretty old if you go in. It wouldn't surprise me. They probably got like some fucking Hewlett-Packard PC or some shit. That honestly wouldn't surprise me at all. That's not like that far from the norm for like these small county courthouses and shit, or at least the few that I've been inside.
Accountable for? We didn't know it. We don't, and
if you send videos from iPhone message to Android's text messaging app and compress the file to the point where it is unusable, I don't even think you can. Sometimes I try flirting with motherfuckers that use Android, and I can't send them fucking videos on text. I gotta get these motherfuckers to switch to apps. You can't do it. Can't send any shit. It's fucked up.
If Ms. Wisco knew it, it wasn't brought up until Friday. Now, there was some dispute Friday about there being different copies. There was no different copy. The software on Ms. Wisco's phone, or whatever software she used to view it, compressed the file. The only compressed file is the one Ms. Wisco has. All the ones that we have seen, and we did not alter the file. None of us know how to alter the file. None of us know how to compress the file. We wouldn't have had time to do so. You can probably go back on the footage and see when Mr. Howard, Detective Howard brings it in, and while Mr. Lukowski's being questioned, we're looking at it to see if it's the drone footage that apparently the defendant's first attorney had or was aware of. And I understand he's different attorneys now, but this is still the defendant's attorney at the time knew of this.
If you wanted to share a video file to Dan from phone to phone and you couldn't use Discord, what would you use? I don't know if that's supposed to be a gotcha, because I'm not submitting evidence to life or death court decisions, but I would probably just use Google Drive, because I pay for a big Google Drive account, so I just throw it on there and then send the link to it.
3 days after the incident, and was talking about it on national television. So to somehow now accuse us of compressing a file and somehow being able to do this technical wizardry to somehow
technical wizardry
sabotage the defense is preposterous. The defense saw this video and thought highly enough of it that they went and bought a large television that is now being used in court because they wanted to show it.
Holy shit.
And now all of a sudden to come back and say, well, we had a bad copy. They could have checked, they could have asked for a thumb drive, they could have asked for whatever. As far as we knew until we had this hearing on Friday, everyone had the exact same copy. And that Ms. Wisco's phone compressed it is not our problem. It's not, we're not responsible for that.
Didn't go to her phone.
If I may.
Well, no, one at a time. One at a time. Well, why don't you start, Ms. Wisco?
Uh-oh.
Can you talk into a microphone? Yes.
Oh man, it's like, this is like fucking the three kids brought before, is it Professor McGonagall? McGonagall? Is what her name? McGonagall? I don't remember. In Harry Potter? All right, kids. Who fucked up? What's going on here?
On November 5th, 2021, I received at 10:33 a.m. an email from Detective Martin Howard with one video file attached. It was a 4 millibyte video that was titled
Millibytes.
IMG_0159.mov. I have never looked at that video on my cell phone. As soon as I received that video via email, I downloaded it to this laptop, which is the evidentiary laptop we've been using through the duration of this trial.
What manufacturer is that?
This is a Lenovo.
Okay, good.
And
Why? I like how the judge. Oh, Lenovo. Oh yeah, you know, I'm familiar with that. Familiar with that system. Yeah, they don't do anything weird. Okay, yeah, go on.
I relabeled it after it had been brought into evidence by the state as Exhibit 73 because it was Exhibit 73 for ease for bringing it up, showing it to the jury. After we found out in Friday that there was this discrepancy after the videos being shown, and for the record, we did not buy that TV because of this drone video. We actually brought it in for John Black's slowed down testimony. That was the reason we brought this TV in. However, when we were in court, I played the Exhibit 73 on my computer because the state's computer wasn't here. ADA Kraus was the one who brought up the fact this isn't the good quality video. We didn't realize until playing them side by side, mine and then the state's, that there was any difference in quality. That was Friday. After Friday happened, I emailed both Binger and ADA Kraus, and I asked for an exact forensic copy of what they had given to the state crime lab. ADA Kraus responded back to me, forwarded me the email he's talking about to Detective Howard, and that also contained one file named as IMG_0159.mov that was a 4 megabyte file. Simultaneously, ADA Binger had been in contact with me.
What is it? That's not even remotely close enough to be a fucking video file for what they're talking about, right? Like, how long was this video file? What?
Told me I could come pick up the file from a flash drive. I drove here, I had him take me inside, and I confirmed that this file that he said was directly provided to the state crime lab was an 11 megabyte file, not 4.
Uh-oh.
So the information contained in the flash drive was over double the size, almost 3 times the size as to what was emailed to me. When ADA Kraus followed up to me with that email, forwarding me his email from Detective Howard, it was the same 4 megabyte file that I had gotten previously.
So clearly Attorney Wisco's email is compressing these files. That's not our responsibility.
Uh-oh.
I
It's a debate?
I didn't write Outlook software.
You know what?
I forwarded
But wait a minute, I don't know if she had finished.
Every other piece of evidence from the state crime lab in this situation has been provided to us via Dropbox. Dropbox provides an exact forensic copy of what they have.
Oh, true. Actually true. The boomers are impressing me. Actually true.
File title name in this situation should have been exactly the same as the one provided to the state if it was the exact same copy. The file name was nowhere near similar. The one that was provided to the state's crime lab that Attorney Binger gave me a copy of on Saturday had a very long, convoluted title that involves lots of letters and numbers that are the type that are usually associated with files taken from a drone because they indicate a lot of different information like the location of the drone and the time.
That's actually true again. How does she know that? Dude, the boomers are bringing it home. Damn.
The file I received originally on Friday the 5th was not labeled that same and was not the same file amount.
Actually, I'm sorry. You're right. Hold on. I assume everybody's a boomer, but she looks like she could be like in her late 20s, early 30s maybe? I can't, no, hold on. That hair color is natural. Wait, if her hair is actually graying, then she might be like 40s or 50s. Wait, do you think that's her normal hair or no? She might have just dyed her hair. I can't. She sounds very. If I'm looking at that as her natural hair color, would a woman in her 40s be that grayed? She could have started graying and dyeing it. She doesn't sound like she's in her. Dario says mid 30s for sure. Fluke says easily 40. I started going gray at 18, somewhere between 20 and 70. Maybe a Witcher fan? Okay.
No way that what ADA Kraus is saying is true because
We've got late 20s.
the file name would not have changed if my computer was compressing anything. It was a different file that we were provided from what was provided to the state. At least for what Attorney Binger gave me on Saturday. They're completely different.
That's going to be a big yikes.
Confusing the issue here. The work product of the state crime lab is sent via Dropbox. That's how they've submitted all the videos that they worked on and the photos they worked on.
Yeah, but
The email from my personal Gmail account is the file that went to the state crime lab. I was told to bring it to the state crime lab. I was already home on Saturday. I did not have access to anything but my computer. I had Detective Howard email it to me, and I put it on a thumb drive at home, and I took it to the crime lab.
Oh my God, he's like,
I don't know if
he's realizing halfway there, he's like, oh fuck, I fucked up. Oh my God, I just fucking told a whole dumbass fucking lie in front of the judge.
Mr. Binger somehow retitled it, but the image I gave.
Mr. Binger's like, hell no, Brady, you're laying under the bus on your own on this one. Did you see him shake his head over? He's like, I ain't retitled shit. I'm not going down with you on this one, motherfucker. I only make $50K a year, okay? I'm not here to get shouted out on fucking national, international YouTube videos.
I
watch his head, watch his head here.
Mr. Binger somehow retitled it, but the image I gave the crime lab is on my phone.
He's like, hold on, Your Honor. Let the record show that I shook my head no here, please.
As the title that she indicated.
They look like two kids that just got caught with like they ate all the cookies, but they accidentally didn't eat one, and like somebody found it underneath the bed, and the mom was like, so why was there a cookie underneath your bed? Did one of you bring it here? And he's like, not me, Mom. You're like looking at the other siblings. I'm sorry, buddy. You're going to timeout for this one. You're losing computer privileges for the weekend here.
That was the one that went to the crime lab, and I will testify as an officer of the court. I take offense that what I'm saying is untrue. Clearly,
well, we're going to have to take this testimony under oath, and we're going to have to get somebody to explain all this.
Oh shit!
Who has some competence, which.
If you look at the report from the state crime lab, they indicate the originating file that they received was the one with the expanded title that we did not receive until Saturday. If it had been the same file as 88 Kraus says it is, why wasn't that labeled on their receipt as being IMG 059 or 159?
Oof.
Mr.
If that
Kraus?
is the exact same thing, then that does not add up.
Mr. Kraus?
Why did he include in his report a different title?
I'm looking at the email. It is image0159.mov. When it's downloaded to computer, perhaps it has a different title. On my phone and on my Gmail, that is the image. I'm watching the video right now. This is the precise one that was given to the state crime lab.
You're watching it to determine it? You're on your fucking phone? Are you even using a good phone, or is this like some fucking like OnePlus like version 12, or I don't even know another type of like, I don't know. OnePluses are fine. I'm sorry, I didn't mean that way. Okay, but like, why are you looking at it right now? As if that's gonna? The judge is like, oh well, you're looking at it. Oh okay, I'll take your word for it, Chief.
I had no other access at this point. The first time this was ever put on any kind of hard drive is when I did it Saturday at my home. And I'll do a little experiment here. I'll save it to my computer and see if the title changes. But
we're going to do this. Pardon me?
I accidentally saved it 3 times because I was trying to re-download it multiple times, and it all saved it as IMG 0159.
Okay, well, you know what? We can't resolve this now because this is going to require expert testimony from people, and we're going to have to take testimony under oath as what the facts are, and so that I'll reiterate my comment, which started this discussion, which was that given the cloudy picture about this particular exhibit, this is a high-risk strategy for the state. I was queasy about this from the beginning, and I'm only queasier about it now.
He was queasy about it in the beginning, but his ultimate ruling was we'll let the jury decide, right? That was his initial. He did rule in favor of the prosecution on this originally. The real question is does this drone footage that's up for debate right now, does it include that highly pixelated moment? Or is this just the moments afterwards where Kyle is shooting Rosenbaum? Because even in it does. Oh, so what did we end up looking at on trial? Was it the highly compressed version or?
Show the jury the exhibits. I'm really not concerned about the image. As I've said multiple times, I believe much too much has been made of this image. Mr. Binger didn't even mention it in his closing. We didn't show it in either our closing and rebuttal. The other evidence was admitted without objection with a stipulation to authenticity, and I believe it should be played. It's already been played for the jury, and they should be brought down, and we can put all the other exhibits on a thumb drive outside of 160, what is it? Outside of exhibit 155, which is the image that the court has received over objection. but the other exhibits were not objected to. And again, the defense, although a prior attorney, had access to this video 3 days after the incident. So to now claim that they're somehow prejudiced is preposterous. I understand it's previous counsel, but it is still the defendant's attorney. He was charged with this crime, and if Attorney Pierce did not turn something over that he had and that he seemingly brought to the Tucker Carlson show, that also is not our responsibility.
Your Honor, can I briefly respond to that?
Yes, sir. Yes, sir.
Mr. Pierce was my client's attorney. As Mr. Kraus said, Tucker Carlson purchased that video. That video is very different from the video that was delivered here in quality, color, there. We stipulated to the video based upon what they gave us. We didn't see it as anything different. We were given...
I want to stop you now.
Okay.
Because why do you say that the one that Mr. Carlson bought, Tucker Carlson bought, is different from...
Black and white.
Ah, that was, okay. Go ahead.
Well, that'll do
We
it.
stipulated to that video when we looked at our copy because it didn't add anything except color. We didn't have the quality. And that's where this whole problem starts. And we weren't aware of the quality until after the evidence had closed on Friday, when we were here and it was plugged in, as Ms. Wisco was saying. That's when we found out there was a problem, what had been given to us versus what they had. That's when the whole problem comes up. So that's as to that video. The other one, and I'll just say it because it's going to be an issue, FBI aerial with all POI'd marked. That, when we're going over this list, it's come to my attention. I played that for the jury. It never got marked or moved in, even though it's been played.
Are you kidding me?
I am not kidding you,
Can we
Judge.
put it in evidence now?
That's what I think would be the proper way to do it.
If the defense agrees that all the drone videos go back, we will agree that that should
Can
be
I
marked
run a
in
compromise?
evidence.
This isn't, let's make a deal here.
Did they try to get other previously tossed evidence back in on the agreement of on the agreement of them getting this video? Come on, wait, what? You're the one. Damn. Now that's some brazen shit. Holy shit.
That should
Can
be
I
marked
run a
in
compromise?
evidence.
This isn't,
The defense.
Sorry.
That's what I think would be the proper way to do it.
If the defense agrees that all the drone videos go back, we will agree that that should
can
be
I
marked
run a
in
compromise?
evidence.
This isn't, let's make a deal here.
They did not mark the evidence. They did not move it.
But it was played to the jury.
Yes, and not marked or moved.
I thought it was part of the hard drive because everything was going in.
Wait. Hold on. I'm sorry. So I understand this. Are they saying that they played a video to the jury that wasn't submitted to evidence? That can't be what they're saying. I must be misunderstanding that, right? You're not... Are you normally allowed to do that? That's gotta be, there's no way. I don't even know why I'm asking that. The FBI video is separate from the drone video.
And I thought we gave them a full and complete copy of the video.
Oh, okay, I understand. It's over the same video, okay.
Well, I'm going to reopen the evidence and admit what they saw. Give it the next sequential number.
Well,
How can I not give it to them? You tell me.
I mean,
Wait, what?
then I would ask that evidence that's been admitted also go to the jury. That has been legally admitted in front of the jury. And follow the proper procedure.
Let's take one thing at a time.
Your Honor, just for the record as well, there was an additional difference that we found in the metadata between the two videos, is that if you look at the metadata from the file that we received from the state, is their create date is 11/5/2021 at 15:10:31.
Oh, no.
If you look at our video that we were provided, the metadata, the create time is
Oh, no.
21 minutes and 19 seconds later.
Judge, I'm watching we're looking at the
Oh,
Tucker Carlson
no.
interview with Attorney Pierce. It is not black and white, it is color, and it actually does seem to be high definition, like this video.
Oh, what?
we're watching. It's online. You can watch it.
What I have is black and white.
He's like, also, I'm colorblind. I'm sorry, Judge. Wait, what did the defense, does he have a black and white TV at home? What was the other guy talking about?
Mr. Rittenhouse's attorney has seen the real version.
He's like, I don't want to look at that. That's an iPhone, okay? Get that airdrop piece of shit away from me.
What about that? If his prior attorney, he's got it.
I don't know. They said that Tucker Carlson bought it. And that's what goes to this whole thing, this urban air. We sent out an investigator to interview the owner of Urban Air to try and get this video. And I can get the report, I don't have it with me. And the individual lives out in the Lake Geneva area, and he lied to our investigators and said, we are mistaken that the drone permit wasn't for this video. And now it's come from his company. He shut down his company 17 days after this video was released. We've tried to get this video, and then it shows up on the Friday
in court
after the trial has started. And it's dropped off by his employee, not the person who we interviewed who owned the company.
Oh, wait, why would, oh man. This is some sneaky shit. Uh-oh. How you gonna bing your way out of this one, Binger?
I don't know who was interviewed. I believe that is the owner Mr. Beeman? Oh.
I'm shaking my head, no ice.
Wait, hold on. Let me clarify prior statements that I've made, and then, or you guys just being dumb and misunderstanding me. Do you defend all the BS the prosecutor side is doing because it's their job to tell a narrative? Genuine question. You're not allowed to fucking lie or break process or withhold like exculpatory evidence or do shit like that. Like you can't. You have to work within. It is your job to do a prosecution. That's what your goal is, but not at all. Not like at all costs, but within the bounds of the law. You're held to a slightly higher standard than the defense, right? You have to seek justice is like your calling. So it has to be a good faith attempt to put together things that are right. You can't do whatever the fuck these guys are doing.
Well, this is number 5, and they say, please prepare. And then it lists these things, and then it says, we will request when ready, and they haven't followed up. So I'm playing short. Maybe the ball won't come to me.
So, well, if we're moving on, at least for the moment, let's go to number 4.
Yeah.
So it seems that the request, it says view video, but I believe it's
apparently when the camera panned away, somebody caught a picture of they caught a picture of Binger. What is happening here?
actually, I believe, 3 videos.
I did not hear you, sir.
Hard to see with the transparency. There you go. Is that better for you?
Ask for a video, but I believe they're actually asking for 3 videos, and I think we agree on this, that it asks view video starting with Mr. Grosskreuz's interview with Mr. Rittenhouse. That is Exhibit 3. It's also duplicated as Exhibit 57. That is the live stream that Mr. Grosskreutz took that night. That does not actually depict the second incident. It does, you can hear the shots, but then it asks to 10 seconds after Mr. Grosskreutz shooting. I believe that's what's referred to as the BG on the scene video, which is number 5. And then it indicates in regular and slow motion. The only slow motion of that incident is the BG on the scene video, and that was the one that Dr. Black created and played. That was moved and admitted. It does not formally have a number. because it's on a drive. We do not object to it being given a number and sent back, or, well, played however the court deems appropriate.
Hold on, just a couple things. People bring this up, okay? Destiny's just laughing and implying the prosecution did this on purpose while we're watching the same video disproving that. I seriously doubt anybody would do anything like this on purpose. This would be an incredibly fucking brainless, like, stupid thing to do. Now, wait, it's possible, but I don't know if that's the case. Also, somebody keeps saying over and over again, prior video footage shows that his computer has 2 compression softwares called Handbrake and File Factory. That laptop might be like a company laptop, or it might be something that his law firm leases out to people, or it might just be a work laptop that's shared around a whole bunch of attorneys or other people working on the case. There's no guarantee that just because he has that program on his computer, he knows anything about it. I seriously doubt that's the case.
So,
Or it could be, but it's not necessarily.
We would ask that, so I believe there's 3 exhibits they're requesting. The state does not object to them having access. However, it is deemed appropriate to those exhibits.
All right. So, and there, that's by agreement, and then the question is where and what restrictions will be put on their use of those videos.
The state's position is that they should be given the exhibits or told what numbers they are. The courtroom should be cleared. They should watch them on the monitors they've been watching the whole case on. And that can be set up, and then everyone can leave and they can discuss it. Now, it says...
All by themselves, or...
By themselves.
Okay.
Just as they are
I
in the jury
assume
room.
that somebody has got the technical ability to trigger playing of the videos.
That's a fairly simple process. We can...
Is anything
they can
simple?
Give a computer with the... You just plug it into the side, and then they can just press the thing. If there's...
Either it doesn't have other matter on it.
We have... I believe our computer, if it doesn't have anything else in this case, it may have like Microsoft Word or something on it, but there's no other evidence of this case on it. It's not my computer. It would be we have some standalone laptops to do this type of thing.
What's the defense position?
Judge, we were talking about it, and the question that I have, and I don't have an answer because it wasn't in any of these cases, is there any right, if we're doing it in court, is there any right for Mr. Rittenhouse to be present?
More than if they had paper exhibits
Why would he
they
need to be
were
present for
discussing
this?
them, and certainly the defendant can't be in the room while they're talking about them.
Well, I agree
Why
with
is
that.
the video different?
Well, if you clear the room and say this is now the jury deliberation room, which is what they've asked.
No.
Oh.
I want to go back a step. Okay. Supposing I said, well, let's just get a computer that has nothing else on it, or that is everybody feels it's sufficiently sanitary, and let's put these exhibits on a flash drive or download them onto the computer, whatever, and then send that upstairs. Let them do it just like they would if they were paper exhibits, and they can play it and discuss it as much as they want. Now, I'm talking right now only about question number 4, because there's other issues with respect to question number 5, and fortunately they're not here yet because they haven't requested it. But this would be a departure from the Anderson case for sure. That would not be incompatible with what I did in the Flint case. Flint. Who's okay with that?
I'm sorry?
Who's okay with that?
With what?
We're okay with that.
Oh, okay.
Is based on what you said, so we're not waiving anything on 5.
You're not waiving anything on 5.
Then that's okay for 4.
Okay, now we just need to get a clean computer. And you say you have some available, Mr. Krause? One of those?
I have to look at it, but it can be clean.
Look at it. Well, I'm going to go and do something else. I'm not going to go. I'm going to stay. I'm going to stay and do something else. And I'll let you fellas try to work this up. And
At this point, Your Honor, they have not requested what we're fighting about.
they have not requested.
At this point, they have not requested what we're fighting about.
You are correct.
Okay.
Windows Media Player is the default. However, if you try and play them through that, nothing comes up. Sure, we can reset the default.
Okay, so we're all on board with that. Mr. Rittenhouse, you know what's happening here?
Yes, Your Honor.
Any question about it at all?
No, Your Honor.
Any problem with this?
No, Your Honor.
Okay.
Judge, while Attorney Wisco is preparing the computer, during this little break, we've done some more looking, and in terms of the drone video, I don't want to re-argue it, but I just want to state what happened. When Detective Howard obtained the video, he airdropped it to my phone, which is a lossless type procedure, or at least it didn't change anything. At some point, I emailed it to myself, which did not change anything. It has the file name, the long file name. I did ask Detective Howard to email it to me as well. Then it had the IMG file name that Attorney Wisco received. So somehow in this Detective Howard transmitting it to everyone, if it was emailed, it was compressed. If he airdropped it, it was complete.
Here's a question for the tech people. If you zip a video file, does that compress the data? Or, I'm sorry, is that a form of lossy compression on video data? Because my understanding is that zipping is a very primitive, basic form. Like for text, it might help, but I don't think zipping will do anything with like audio or video generally. And it's not lossy either, okay. I wonder if Outlook or whatever they emailed it on has some automatically like, your video is too big. Do you want to compress it? Like I know that there are, I think Discord does that, maybe. Instagram might. I wonder if there's some sort of automatic video compression on some email thing.
And that was not known by anyone until a few days ago on Friday.
It compresses the size, but the decompressed result will not have any loss. For a zip file, that's true. But for audio, probably for audio. For video, if you're compressing a video file, it's almost certainly going to be some form of lossy compression. That would be my guess. But we'll see.
Well, it depends.
I'm not talking about zip files when I say that. I don't think you can put audio and video in a zip file, but I don't think it's going to compress it very much. Or somebody can try right now. I don't know. Like right click a video and do add to zip folder for audio or video. I don't think a zip file is it's not going to compress it very much.
This may pass. They haven't asked for it yet. They wanted us to be ready, and of course we're not. But let's take a step at a time. And I just heard their bell ring, so perhaps they have something more of interest to us.
So, Judge, we've been talking. If they do come back with question number 5 or whatever it is, whatever. You have talked about in great detail and length, and it's completely appropriate, the transparency of wanting this to be a fair trial and everything else. And I'm finding that difficult in that one of the linchpins of the state's case was information. Go ahead.
I'm just going to interrupt you long enough to have the material that we've agreed to go up. So if that's ready, Ms. Wisco, we'll have the
They're talking about sending it to the jury, I think, for deliberation.
They're ready for the video. I don't know what that means. But let's send up number 4, and then I will hear the rest of what you have to say about number 5. So is that ready to go up?
Yes, I'm having a
Okay, hold on. I can't tell who's trying to explain stuff about compression to me that knows less about compression than I do. Okay, I'm not sure. Let me read through some of these comments. I can't tell if people are trying to explain things to me that they don't know as much about as I do. So, Destiny, when programs resize files to send, they're changing the bitrate / resolution / frame rate normally when iPhone sends to Android, etc., to fit within certain limitations, so it's definitely lossy. Now, if you're talking about simply zipping a file, on things like text documents, it is incredibly easy to compress a lot of text or these types of things in ways that you save a lot of file space, and it can be restored to the original file very easily. But in order to compress video... Wait, who's saying wrong? You're IP banned. I don't even know if you're trolling. You get fucked, retard. Okay? If you're talking about compressing audio or video, the types of compression that you need for those things are far more sophisticated than just right-click zip file. That there are tons of, like, this is where we get into like what is like MP3s or like the OGG format or for video compressors. People have been trying to refine and perfect like video codecs and video compression software for a long fucking time. Compressing video files is a very, very, very arduous and difficult process. If you right-click add like a fucking 500 megabyte video file to a zip thing and it does it in 2 seconds, you're not compressing shit, okay? It's probably saved a little bit of space on like the metadata and maybe some other text things, but the file size is gonna be pretty close because in order to compress video information, that is an incredibly sophisticated form of compression that's not as easily done with like a Word document, okay? Okay, we're done, okay? Stop.
Problems with setting it as the default because of the way that I sanitized the computer just now. So if we can go up with the note saying let's play.
Send the note up. Have the DA look at it and make sure it's okay with them.
If you could make sure they plug the power cord in because the battery is low. It says must play all video.
There are a number of lossless video compression algorithms. Sure, there might be. There also might not be, okay? When it comes to audio, there are lossless compression albums. Lossless meaning you get a bit-by-bit copy, perfect copy, and it compresses it, meaning it's less data. So you've got like FLAC, you've got ALAC, I think WAV might be lossless. And I'm sure for video, there are probably lossless compression albums as well. But guess what? Lossless compression compression? Oh my God, I'm losing all the words. You guys are triggering the fuck out of me, okay? Logarithms. If you're making a lossless video file, okay? I'm using these words so much I'm losing my mind, okay? If you are compressing a video file using a lossless algorithm, you're not going to compress it very much, okay? The whole reason why compression usually cuts down on the file sizes so much is because you're editing out some of the information, all right?
Through VLC media player.
Destiny, sorry, I'm talking specifically when programs auto-transcode files to fit file size limitations before sending. If there is a program, this is what I would make an assumption about, okay? And I think it's probably a pretty good assumption. Here's a pretty safe assumption. If I'm working on a program and it is ever offering me to automatically compress a file, my guess is almost every single time that is going to be a highly lossy form of compression. Because lossy compression is computationally easier and is always going to result in lower file sizes, okay? If anything is automatically offering you to, oh, we're going to auto-transcode this for you, we're going to automatically compress this file for you, it's probably using a lossy form of compression. Because nobody gives a fuck about uncompressed data generally, unless you're working in very specific areas. How does he know this? Because I've been a streamer for 11 fucking years. Because I know a lot about fucking file formats and video compression algorithms, and I used to do a lot with like music shit, so I know about music compression algorithms. Like none of this stuff is that hard to learn. You can look at this in a fucking wiki and read this in like 10 minutes. Not even, in like 5 minutes or less, okay? Destiny, lossy versus lossless doesn't really speak to how much processing it takes to compress. I don't believe you. I offhand don't believe you. Like, if you have a lossy file and a lossless file, wait, hold on. No, never mind. You're partially right, actually. Because you might be able to do some lossless compression fairly easily. But for the same data rate, for the same data, if I were to take one file that is, to try to get it to as low a file as possible, to low a file size as possible, you're generally going to be using lossy algorithms there. My guess would be that if you're using a lossless algorithm, you're trying to compress something, but that's not necessarily true. Sure, that's probably not necessarily true. I'll say to get to a smaller data, or a smaller file footprint or whatever, you're almost always going to be using a lossy algorithm to do so. Because there could theoretically be an incredibly simple lossless algorithm. It just can't get us over there. Sure, it's possible.
Question 4, it's coming up. Yeah, go ahead.
Please keep it open though, so then they don't have to log in.
Yeah.
Thank you.
Jesus. Make the judge mute his mic.
It's no longer allergies. It's a cold. But go ahead. Yeah, there's no restriction on their use.
So, Your Honor, we were talking during the break, and the reality of it is one of the main portions of the video, the thing that you watched, however many times you watched it, right, on a video that we had the video, not the clarity and not the quality. I think that's been conceded that we didn't have that.
True.
We were talking about, we would have done this case in a little bit different manner if that was the situation, where we didn't have specific, and I want to say we didn't have the evidence because I don't think that's a fair way to say it, but we didn't have the quality of evidence that the state had until the case had been closed. On Friday, the parties had rested, and we were going to open our closings on Monday. We've talked to Mr. Rittenhouse, and I'm going to be asking the court for a mistrial based upon the fact that if we're really trying to get to the heart of it, we've watched the video, I can tell you what we think, but it doesn't matter what we think because we don't get to present that to the jury anymore. And I think if we're going to try to do this in a way that is free from anybody hiding anything, anybody not having the same evidence as everybody else has, where it is clearly a level, fair playing field, we have to ask for this, and I'm asking for it. We understand that it's going to be without prejudice. We understand that the state can redo this case if the court grants it. We understand they will do it again. But then I think we will all have the same information, the same quality of videos, and I think that is required in a case like this where he's looking at a life sentence, potentially without parole if he's convicted. And to not get that until the evidence has already been closed, that doesn't strike me as fair. So for those reasons, I'm making that request.
Is that one piece of evidence that important? So so in court, the pixelated version of Kyle Rittenhouse raising his gun, that was given on the HD video. It might be the case that if these guys had that knowledge, like before, that they would have had, that they maybe would have spent more time addressing. Because did they ever say, like, maybe he's raising it with his other hand? No, they did, actually, because the guy stood up and he tried to raise the firearm with his other hand, right? But they might have spent more time doing that, figuring that out. Yeah, maybe. Do you give any credence to how long the jury takes in deliberations? For example, the longer it takes them to deliberate, the more Kyle's in trouble. I don't know, dude. It could go either way. I have no idea.
All right. I'm not going to invite the state to respond yet because the jury has not requested to see number 5, and it'll still have to be addressed because the jury saw it here in the courtroom. But
I'm sorry, Judge, but if I understand Attorney Trofsky's request, this is a motion regardless of what the jury is requesting.
I think we're making that request because it's been shown, it's been pointed out, and in fact, we didn't have access. And I'm at this point, I don't think me pointing fingers and doing that is going to be the end-all, be-all. I think what it is I can tell you, and I think the state can tell you, we got a compressed version, which was not of the quality that they had. We learned that Friday, after the evidence had been closed. We learned that when we tried to play the video, for Your Honor, and the state asked that their AV person be brought over to play their video, which was a higher quality. If this is a disorderly conduct or something, I get it. But we're talking about a potential life sentence here. So I'm making that request.
and again, I'm going to say that it has to be addressed if there's a guilty verdict on any degree. on that count, well, even perhaps on the others too, I don't know, it'll all depend on a number of factors, then the motion will have to be addressed. But it doesn't seem to have the urgency right now until the jury, if and when the jury asks for number 5. That doesn't change the fact that they're making the motion, or that it could affect the case as a whole. But I'm not going to invite your response now until I know whether the jury wants number 5. Does that make sense? If it doesn't make sense, tell me. He was told that they were ready for everything. So, that you have the state's response.
Response invited.
Yeah.
The defendant's first attorney, after he was charged with this case, appeared on an interview, appeared alongside the high-definition version of this footage. I understand he's gone through other attorneys since then, but the defendant himself would have been aware of it. His legal team would have been aware of it. Obviously, both sides have attempted to get it, and we were not able to do so.
What do you mean you couldn't? If you know Tucker Carlson's got it, you could have.
You can subpoena. Yeah. What do you mean you can't get the footage? This is a fucking trial. You can subpoena for footage if you need it. What do you mean?
That until I think today.
No, we knew it.
What did you think it was?
We knew it was aired on his show. We didn't know that Fox News apparently purchased and has possession of it.
Okay. Did you inquire?
We tried to find Brennan.
We tried to find the person who took the footage and who ended up being the person who came to our office with it.
I interrupted you. Go ahead.
So this is not a video that was in possession of the state in any way, shape, or form. It was out there in the, I guess, on the internet and in the world in that regard. And I think we're focusing on too heavily on, I guess, a technological glitch, and less on and we should be focusing that this exhibit was played. The jury is asking to see exhibits that they have seen and that the defense saw when they were played in court. What's on my phone or my laptop or the defense's phone or laptop is of no matter. What matters is the exhibit. And that exhibit was played. It was not objected to. The authenticity was stipulated to. And the defense, I understand they didn't realize it till Friday, watched this exhibit. They watched it on a television set a few feet from them. They could have watched it on the...
This is such an insane... Like, how are you going to be able to look at it and just go, wait a second. Is that a 1920 by 988 resolution video? Because we were only watching a 720 by... Like, how no one is going to know that, dude. No one is going to be able to look at a TV and fucking recognize that. Jesus.
Monitors here. That is what matters. That is what the jury sees. That is what they have seen. That they want to see it again is not prejudicial. It's not prejudicial in any way that the defense had a compressed version now. Obviously, they had seen or had a full version at some point, possibly prior to Attorney Richards becoming the primary attorney. But that is not the fault of the state. And the fact that that some technology compressed this file without anyone's knowledge until Friday is not the responsibility of the state. And Defense Exhibit 41 has this video in it. So to pretend that somehow they're surprised or they didn't know about this video, they've tried to find it just as we did. We found it and there was a technological glitch. Or not a glitch, but I guess it worked in a way that is designed that we were not aware of. And Exhibit 41 not only has the drone video in it, which is the defense exhibit, it also has a circle around someone pointing the gun. As I said in my rebuttal, this did not seem to be a great issue until the defendant testified otherwise on the stand. And now all of a sudden, the defense is calling into question technology and not wanting videos in, and it's all to protect their client. And I understand that is their job. I'm not criticizing them for.
I'm curious if the defense knew that this video and Kyle raising his gun was going to be an issue, because there have been other videos now publicly that have been presented that show that Kyle was not raising his gun. That's like, that actually, which, and this is, it's a very weird world to be in, because arguably the defense's biggest piece of evidence is a grainy footage video showing that Kyle Rittenhouse was raising his gun, which is the provocation that leads Rosenbaum to attack, which sets off the whole chain of events. But now we've seen other video footage shows that that's not the case. It's actually just, it absolutely did not happen. We've got other footage from another angle that shows he didn't raise his gun. The prosecution, sorry. So if it's like a retrial, if this is a mistrial and they try it again, would that, because I don't think you can bring, well, no, you can't bring any new video footage now because the prosecution and the defense arrested or whatever. Link?
Now, a couple things.
But this is from that time from a different angle.
You're going to want to notice here. If I zoom in over on the right of this image, you're going to see all the way on the right that's Joseph Rosenbaum doing his Superman impression with his little cape. And that is Kyle Rittenhouse in the green shirt running with the rifle. Now, look up here. As the camera pans around, you're going to notice something. The first shot you have of Kyle. He's standing there, but he's backing up slightly. His left arm is loose, swinging. Now, if I take a picture of this, you'll notice another interesting detail. As Joshua Seminski is walking towards him...
Oh, wait, we watched this video a few days ago. Fuck. Was there a different video that was released? The video wasn't just compressed. The resolution was cut in half. That's not sure. This video isn't part of the trial. I don't think this video footage made it into the trial, no. But it basically shows that right after the thing was dropped, like the way that his gun is, it's like inconceivable that he had it pointed with his left hand and then, fuck, I'll try to find that video tomorrow, because I remember I watched one on this and I was like, oh yeah, wait, there's no way. That's what I found. It's at the end.
He has a pistol in his right hand.
Hold on, let me...
There, holding up the rifle. That's part of the vehicle. That is not his support hand.
We've also seen the artifact on top of the car that I think the prosecution was saying this is Kyle Rittenhouse's hand holding this rifle.
Screenshot and show you. Why is his support hand already there holding up the rifle? That's part of the vehicle. That is not his support hand. That is not Kyle holding up the front of the rifle.
Because this here, look, this is supposed to be his left hand holding the rifle with his right hand on the barrel. Do we all understand what this is supposed to look like? What the prosecution is trying to say is that in this picture, Jesus fucking Christ. The picture is supposed to be like Kyle's rifle is pointed like this, I think, with him holding the gun like this. And then you've got like one arm here, and then the other arm is like coming around with his hand holding it here. This is the worst drawing in the history of all of drawings. But I think this is what the, oh, I'm booming so hard right now. Hold on, you guys gotta. I think the prosecution is trying to argue here. This is the butt of the gun. Kyle's rifle is aimed this way. And he's got one arm like up here supporting it, and then his other arm is over here with his hand like right here on the barrel. But the thing is that this is being held with his left hand, which is weird because I don't even know if his sling would allow him to do it this way. But the problem is that this thing here that's supposed to be his hand is actually probably like a mirror from a car or something. If you look at it, if you go back a little bit.
The rifle. Let me grab another screenshot and show you. Why is his support hand already there holding up the rifle? That's part of the vehicle. That is not his support hand.
Does anybody have the GIF of like what the prosecution is showing so that I can do like a quick comparison for what they're trying to say? So the prosecution is trying to say this is what in my opinion, this is almost what the whole trial comes down to. Okay, so the prosecution is trying to say that at this point, Rittenhouse runs up, raises his rifle there, see, aims it at Rosenbaum, then Rosenbaum gets enraged, and then he runs away. That's what the argument is. That so he steps here, raises his rifle, and then he starts to run after Rosenbaum chases him. Oh, I'm sorry. He doesn't aim it at Rosenbaum. My bad. He aims it at Zeminski. And then Rosenbaum gets enraged and runs at them. But the thing is that if you look at the video, first of all, his hand that's holding the gun.
Wait, one more time.
This artifact is already here. So this doesn't make sense that could be his hand also holding the gun. And then this guy's trying to show what's actually probably happening is Kyle's firearm is down here like this, or his interpretation, I guess. Although again, it's hard to tell anything. But yeah, going back to this guy,
Kyle holding up the front of the rifle, as would appear in this, as would appear in this. This white dot is part of the vehicle and is not Kyle's support hand, and it is not him holding up the rifle.
but yeah, from like a factual point of view, we know then that this being presented by the prosecution is not quite what happened. It doesn't seem to be the case. Also, there's no corroborating evidence whatsoever. It's literally just this one weird thing. So it's, yeah.
For this, but their client lied about.
But everything that we just watched, has not been submitted to the jury, so they're not considering any of that at all. Oh, and then people have also posted other parts of a video showing this is Rittenhouse running later, so we can see how he's holding his gun with his left hand under the barrel, not aiming with his left hand like they're purporting that he did to Zeminski earlier. You can see him running here, holding his rifle, barrel in left hand, as you'd expect from a right-handed shooter. I think it has been submitted. Did they really make a big deal? I don't remember that. Did they make a big deal out of all the other stuff? But I don't know.
On the stand is the state's position. There seems to be evidence to support the position that he lied on the stand about raising the gun. He was confronted with the exhibit. He denied it. The jury wants to see these exhibits. And I understand there may not be a final ruling on a mistrial until we see what happens or if it's even necessary. And they had their own expert that could have looked at this video, and I'm sure did look at this video, and there were questions at the very beginning of the trial about, and perhaps even before the trial, about the resolution of the FBI plane video, a whole different video. Their expert looked at that. I'm sure their expert looked at this. Their expert must have missed it, that it had been compressed somehow. This is not a resource we had available to us. And I believe the motion for mistrial is inappropriate. I don't believe it should be granted. And coming back to number 5, they're asking to see exhibits that have already been played, and with the exception of the image, exception of 155, were not objected to. And the court has said many times when the state has tried to raise these technological issues, well, there wasn't an objection. And we're asking for the same treatment now, that these were not objected to. The defense has had access to the exhibits. They've had access to the drive, that they didn't realize it and we didn't realize it till Friday. That there was some sort of difference is perhaps unfortunate, but they're also responsible for.
Careful.
I'll withdraw that.
Okay.
So the state believes that we believe all exhibits should go back. Again, I understand the court has concerns over the still image. I understand that might be in
what was he going to say?
Category.
I don't know. It almost sounded like he was going to say they're responsible for making sure they got the right evidence or something like that. But that's bullshit, right? That's but I don't know. I might have just gotten lucky. I don't know.
But in terms of question number 5, and I'll just, while I have the floor, I'll just go through what they are. The FBI aerial.
My guess is in a trial you shouldn't. It's not your responsibility to be like fact checking the evidence submitted by the fucking prosecution or or if the defense chooses to. Like, that's what the fuck. You should be like.
With all person of interest marked, that would appear to be the defense exhibit that they neglected to mark, and has now been accepted. The state also has one, which is Exhibit 25, which has Mr. Rittenhouse and Mr. Rosenbaum marked, but not the Zeminskis. So I assume they mean the defense exhibit, but we could send both back or have them come down and view it, however we do that. The drone video is 73. That's the full unedited exhibit that's been in evidence now for over a week. The zoomed in still image, we all have talked about that and beaten that horse to death, so I'm going to skip that for now. Then the full event video in regular and slow motion, that seems to be the drone video, as that is the only video of incident 1 that was played in slow motion. just as the only video of incident 2 in slow motion was Dr. Black's. So their expert video was submitted. Our expert video is, I believe this is actually 6 videos that they're asking for, which is the drone video. It's spliced out. So it shows the first third of the incident, the second third, and then up until the end of the shooting. And it's in regular and slow motion. And that's exhibits 581, 582, 583. I'm sorry, S81, S82, S83, S84, S85, and S86. And we believe that the jury should have full access to them. They should have full access in this room. And that's our position. I do not believe a technical reality, shall we say, or an unknown technical incident should result in a mistrial.
How would we object?
Pardon me?
How would we object to something we didn't know existed until it was over?
I didn't find that point particularly persuasive.
Oh.
Because, but anyway,
It's impossible for us to do that. And if everybody in this room that's a lawyer has been a prosecutor. Your job is fairness.
Yes.
And being a truth seeker.
Yes.
It's not debatable that it's not fair.
True.
What happened. We can sit here all day and say it's been played. We didn't know there was another version. How is that reasonable?
well, I persistently warned the state
Uh-oh.
that, there's a day of reckoning with respect to these things. My feeling is I had my qualms, and I decided, well, I'll let the jury hear it. I think I made the comparison the other day of the breathalyzer, where the officer doesn't have to be familiar with how the breathalyzer does the analysis, but that's a device that has been sanctioned by the courts, and I just don't think we're at that place with this, and particularly if they've got evidence. I didn't see that in your motion about the manual.
We've learned it since I filed the motion.
Well, if they've got the manual, I don't know. It may be. I forewarned you. You've pressed with this, and that's fine. I've let it in, and my view on it now is where we are. We might as well follow through with it, and if they've got everything correct and it's reliable, then they won't have a problem. If it isn't, it's going to be ugly. All right.
I would just note that the defense, I'm assuming they were paying attention to the trial, would have known on Monday when Detective Entry testified that that version was different.
We're going to talk about it later because I've made the decision. I'm going to be played. You've suggested that it be played here in the courtroom under whose supervision?
This becomes the deliberation room for that portion as they watch the video.
I'm going to be in the room with them.
The same people that are in the room with them now.
Well, why come down if they're just going to be looking at? I mean, are you saying that they come down and hear it with all of us in here?
No, I'm saying everyone leaves.
Okay, well, why not just leave them up there?
Because the screen, watching it on the screen that...
I got you.
And that goes, the problem we're talking about on 5 early is the request 5.
Yeah.
We're talking about the problem.
The last word you said.
The problem we're talking about on request 5 is on the front end so far, and it goes to the same thing with that television, adding the...
This part I never understood. I don't know what the defense is afraid or worried about. Are they just upset they can't use a high def version? So I think Okay, this is a little bit confusing. Let me see if I can explain this, okay? So the defense and the prosecution have two different videos given to them of this drone footage. Now, it just so happens that this drone footage ends up being the most important part of the prosecution's case because it's showing Kyle engaging in provocation or provoking or causing, ultimately, the chain of events that leads Rosenbaum to attacking him and then getting killed by Kyle. So one of the big things about self-defense is you can't really provoke somebody, then kill them, and then claim self-defense. So arguably, this is supposed to be, like this could set the tone for every other killing, right? Or for shooting, I should say, right? Because if Rosenbaum was unjustified, you could argue that the jury probably isn't going to see the future killings as justified either, potentially, right? So I think right now what the defense is objecting to is them showing the video at all. I don't think they want the video shown at all to the jury, but I think what they're more interested in is they want a mistrial because they didn't feel like they had the proper video to evaluate as part of their evidence before this went to trial. In the pretrial, they would have, if they would have had access to the original video, they might have framed their arguments or built their case for Kyle a bit differently against the state. They might have argued about it differently. They might have had a different witness, expert witness. They might have had more testimony for as to what Kyle was doing at that point. Like, yeah. They might have posted. They might have like pointed out artifacts. They would have changed it. They would have changed their approach to this. And if the entirety of this case is resting on that vagueness, and you've got, as you know, as this defense attorney rightfully points out, you know, this isn't like a fucking parking ticket or something. You know, he could be facing, you know, life with no parole. For them to not have a fair trial, and this is not fair now, right? Because the prosecution had access to evidence that they did not submit properly for the defense to evaluate before putting their case together. It just seems pretty shitty. That seems like, I would imagine, I don't know, but I would imagine that's a pretty solid ground for a mistrial without prejudice, meaning the verdict is thrown out and then the state can try the case again if they so wish. But I mean, that seems reasonable, but we'll see, I guess. Yeah.
The pixels on the back end. So now they're looking
Are
at
the prosecutors trying to cover, or did they not know if they would lose quality when they sent it? Could it be a tech thing on both ends? This is just like a standard piece of advice that I give for life in general. Don't assume malice if you can't absolutely prove it, especially when incompetence is just as good or a better explanation. I seriously doubt that the state was like intentionally, that the prosecution was like intentionally trying to fuck around. It probably was an accident. That'd be my guess. But now that they presented their case and everything, I mean, they probably don't want to retry this because more evidence has come out. If they do get, Strophian points out, if they do get a prejudice if they get a mistrial without prejudice, it's going to be really hard to find an unbiased jury. I can't imagine how the fuck a jury selection would go next time, right? Especially when whether or not Kyle Rittenhouse is guilty is basically falling on party lines at this point. Like 75% of Dems thinks he did it. 75% of Republicans thinks he's not guilty, right? Yeah, so this is a difficult one. Yeah.
it on a computer upstairs, and I don't know why they're not looking at this on a computer. Meaning 5. I put my hand. I don't know why they're back end. And it goes to the same thing with that television, adding the pixels on the back end. So now they're looking at it on a computer upstairs, and I don't know why they're not looking at this on a computer. Meaning 5. I put my hand on request 5.
So Sealand Brown, I don't know how the jury, I don't know if juries understand that. It's not that big of a deal, Destiny. The defense has made a record of it. So if they lose, they will appeal, or the judge will mistrial the case. However, there will not be a guilty verdict if the jury understands their job. There is absolutely a reasonable doubt in this case. So that's obvious to me. If you look at the video, I think if you look at the original video that was put out, and we don't know anything else, I think you could say he could be raising his rifle there. He could be, and I watched it, and when it came out, I actually had some questions like he might be raising a rifle, and if he is, Rosenbaum becomes a lot more defensible, and then Kyle's case looks really bad for all 3 shootings, I think. If that actually was the case, and I even said this a year ago when I was covering it, I was like, there are some, like, it seems pretty fantastic, but if Kyle was, like, threatening people with his gun, you know, I'm going to shoot you, blah, blah, and then starts to run away, yeah, that actually changes it quite a bit. However, the job of the jury should be to look at that video and say, there is absolutely a reasonable doubt here that he might not be. No way can I look at these 12 pixels and say it is beyond a reasonable doubt that he's raising his rifle, that he's engaged in provocation. No shot. But it's a jury. The jury might not look at it that way, you know? They might not think in terms of like a reasonable doubt.
And how many times? One time? Is that what you said?
I didn't know. I think just as they're... No, I think they should be free to look at it as much as they'd like.
That would be my bias, frankly. But we've got the law that you cited the Anderson case. I have ruled in the past, and I'll rule again.
Also, the defense has not done a particularly good job making the argument that Destiny just made. Yeah, sure, but again, you got to understand this. Okay, I'm trying to. Okay. Trials are not supposed to be about creating arguments and creating narratives and figuring stuff out. That's all done pre-trial. Trials are just, you bring the people up you want to show the jury, look at this, look at this, look at this. That all a trial is the prosecution and the defense going, look at that, look at that, look at that, look at that, look at that. Not like, oh my God, this, oh my God, right? I've had a lot of time to sit here and watch this and think about this and blah, blah, blah. And I've seen a bunch of other like video footage and everything else. The defense has probably been working on this case for months? I don't know if I would expect them in 2 or 3 days to change up their strategy completely. And also, you might even, I don't know this. No, we're moving into conjecture territory, okay? They might weaken their case by trying to charge, by trying to charge that this evidence doesn't work, and then not have gotten, testimony from some other people that might have been involved. They might say, oh no, we know this is fake. It's bullshit. Really? How? Well, why didn't you get another witness to testify? Why didn't you grab anybody else in the video? Why didn't you push harder for Zelminski's wife to come up here? Why didn't you push harder for something, right? If you're really going to make that argument. So it might feel like now, like, well, fuck, like we can't argue hard on that point because we don't have any witness testimony to back it up. We're literally just telling a story. It might be the case, I could be wrong. I'm not a trial lawyer, but my guess is going to be that if you are a trial lawyer, you're probably never going to want to change course from your set strategy in the middle of an actual fucking trial. That shit is all, your case is all laid out fucking probably weeks or months in advance before you're actually in front of a jury, telling your story.
Not applicable to images of the event, only to like statements and that kind of stuff.
Destiny, I completely disagree. Trial is the most important time to come up with narratives and other things to sling mud. Pre-trials are meant to clear up evidentiary issues. I think you've emailed me and said you're a lawyer. I just don't believe you, though. There's no possible way. I would be shocked if lawyers were figuring out narratives in the middle of a trial. It absolutely must be done prior to that. There's no shot is a trial lawyer starting to try like, you know what? Bring up him to this. Actually, you know what? Fuck it. Bring you up. Come up here. We're gonna talk about something, right? No way. It's got to all be like, we're going to bring him up, we're going to do this, this, and this, then we're going to ask this, this, and this, and we're going to do that, and then we're done, right? It must be all like plotted out meticulously prior to like the actual trial.
But I'll hear you out.
But the trial is absolutely about storytelling. I'm sorry, I might be phrasing this correctly. The trial might be about like telling a story, of course. I'm just saying that the story that they're going to tell is going to be figured out before they actually are in the courtroom, before trial started.
I'm relying on a Supreme Court of this state's case. I understand that you're separating them, and I'm just here to tell you that we object to it being played over and over. What I've learned from...
To be honest, the concept of reasonable doubt seems to be deleted from everyone's brains the second they saw this video. If anyone thinks this pixelated shit show is beyond reasonable doubt, they're lying. So in my opinion, this evidence is useless. True. That is actually kind of a larger, maybe a broader problem, right? Beyond a reasonable doubt, that is an inhumanly strict amount of burden to place on somebody that's prosecuting a case. In our normal day-to-day lives, we do not use that standard of evidence for anything. You won't use it for getting expelled from school. Parents don't use it when they're getting their children in trouble. Wives and husbands don't use it when they're accusing each other of cheating or abuse or whatever. This is a very, very high standard of evidence. All you have to be able to say is that any reasonable person could have a doubt about the narrative of events that the other side is saying took place. But it's most people don't think about that though, right? And there are lots of things where, and I'll even admit, there are lots of videos that I've seen where it's like, oh, this definitely happened. And I might say this definitely happened. But if you were to say, like, if you were in court Would you prosecute on this? And I'd say, you know what? I think it super looks like it happened, but could have gone another way. There could have been this. It could have been that. You know, is it beyond a reasonable doubt something else could have taken place? I don't know if I could say that, right? That's just that standard of proof is not present in our day-to-day lives. So yeah, I would be, but I don't know how many jurors or how many people on a jury are thinking that way. Like, what is beyond a reason? They might see them like, you know what? That looks pretty shitty. Fuck this kid. He's guilty, right? They might actually think that way. I don't know, you know?
Case with the videotape or the cassette tape and Anderson, both of those cases talk about not there being an overemphasis on specific parts of evidence.
Possibly overemphasize a video of something. Unless, I suppose, if it's not an accurate video, I suppose then you could. But then you're overemphasizing it when you see it the first time.
That has been the concern of the court in having them have.
Do you think a mistrial would result in a bigger shit show than a non-guilty verdict? I don't know. A mistrial would be a disaster. I don't know how that would happen. Like, what would a mistrial mean? Finding another jury is going to be impossible. I think the defense's case with all the new video shit, I think just gets harder. Probably because the facts of the case probably support Rittenhouse. That seems to be the case. He probably wasn't acting with provocation towards Zelminski. It doesn't seem to be the case that, you know, he was threatening people. Like, or if that evidence exists, they didn't find it in discovery, and I haven't seen anything else on the internet to suggest that. So I don't know. Mistrial, my guess, always a guess, but my guess is going to be that the mistrial would probably favor the defense, but who knows?
When I say them, having the jury have just unfettered access to it, in Anderson and in I think it's Franklin, that was the part of the concern in both cases.
And I will repeat, I think it's the fact that we have to censor what the jury uses to just.
But if the jury comes back with a guilty charge and then the judge grants a mistrial or a mistrial with prejudice, which I can't imagine, but if they did, oof, that now we're in like, oh man, the white nationalist judge absolutely did this. Like that's, I don't know.
When the founders of the country gave them the power, it has to be censored by the judge. That's really insulting. So certainly I'm not going to say there aren't cases where a jury could overemphasize something, but for me to say, well, there's a video that is purportedly an accurate depiction of what happened, and you can only look at it so many times, I'm not going to do that. So they know the risk and they've assumed it, and so they can watch it. They'll do with it as they see fit.
So I understand they're ruling the videos. We do not object if the zoomed in image is not sent with them. 155.
Well, I'm going to leave you gentlemen to confirm, and as you did before, and came up with a workable.
How do you wish? Should we put it on a drive and send it to the jury, or are they coming down here?
Why don't you give them a drive, because then they've already got the clean computer to work with to put it on a drive.
I want to use this.
And then they'll come down here, and presumably they know how to work it, or if they haven't told us they can't. They can come down here and they can.
All 12 juries are fiddling with the laptop. We don't know the password. 12 hours later.
Operate it from wherever they're comfortable, and we'll all clear out of here. And okay.
I will work on that.
Okay, you confer and come up with an agreement to which you object. A working agreement to which you object.
Is there anything else here, or are we good?
Now let's do the case of the state against Emmett Zier.
Oh, another case. Check out David Pakman's reaction to the mistrial request.
In a little bit different manner, if that was the situation, where we didn't have specific. And I want to say we didn't have the evidence.
That's a classic from attorneys. Had we known, we would have tried this case completely differently.
Well, I mean, that's totally fair. What?
State had until the case had been closed. On Friday, the parties had rested, and we were going to open or closing.
Had I had a different collection of facts, I would have told a totally different story. Yeah, no shit.
On Monday, we've talked to Mr. Rittenhouse, and I'm going to be asking the court for a mistrial based upon the fact that
Here we go.
we're really trying to get to the heart of it.
Guys, they know that with 14 hours of deliberation, there could be a guilty verdict coming, and now they want a mistrial on this evidence.
And I think if we're going to try to do this,
They didn't know that this evidence wasn't what they thought it was until I think until last week, until everything had ended, until the jury was gone, until the case had rest. Like, this was the first time I think they had a chance to bring it before, or they might have brought this up like yesterday, the day before, but I think it was Friday after everything was done where they even knew about this.
this in a way that is free from anybody
There it is.
hiding anything, anybody not having the
They brought
same
it on
evidence
Monday.
There it is.
everybody
Yeah.
else has, where it is clearly a level, fair playing field. We have to ask for this,
This is insane.
and I'm asking for it. We understand
It's not insane at all, though.
that it's going to be without prejudice. We understand that the state can redo this case if the court grants
Wow.
it. We understand
They know there's a guilty probably coming on something because they've been
How do you even know that? There's no way anybody know. What are you talking about?
deliberating 14 hours and they want video. And now he says throw the whole case out.
the same quality of videos.
Hold on. So when did they submit this retrial? Was this before jury deliberation even began? Rittenhouse's lawyers had said in court that they had planned to ask for a mistrial before they filed papers on Monday. The case went to jury late Tuesday morning. So he's actually psychotic. Pakman is experiencing psychosis right now because Rittenhouse's lawyers had planned to ask for mistrial before they filed papers on Monday, accusing the district attorney of bad faith. The defense claimed that the drone video was compressed into a 3.6 megabyte file with lower quality image. And this motion was filed on the 15th. Prosecution for defense footage. This is the defense footage that they're talking about, is item 12 here. This is dated the 14th of September. This is actually just delusional. He's just completely wrong. They're not waiting for anything. They'd already had this in the works. That's a different motion that's with prejudice. Sure, this might be a different motion with prejudice, but they're referring to the same evidentiary things, right? The file size of the defense video is 3.6 megabytes. The state's is 11.2 megabytes. Like, they've already, this stuff has already been in the works before trial, before jury deliberation. It's not like, oh my God, the jury's deliberating so much, we got to make some shit up and then blah, blah, blah.
And I think that is required in a case like this where he's looking at a life sentence, potentially without parole if he's convicted. And to not get that until the evidence has already been closed.
Wow.
That doesn't strike me as fair. So for those reasons, I'm making that request.
All right, I'm not going to invite the state to respond yet because the jury has not requested to see number 5, and it'll still have to be addressed because the jury saw it here in the courtroom. But
I'm sorry, Judge, but if I understand Attorney Trofsky's request, this is a motion regardless of what the jury is requesting.
I think we're making that request because it's been shown.
Wow, they want a mistrial either way.
In fact, we didn't have access, and I'm at this point. I don't think
The thing that I don't understand, okay, fuck, I'm so blackpilled. I'm blackpilled on everything now. David Pakman's coverage of this is actually the ultimate black pill, because my prior charge to this was that I think that a lot of people don't know anything about the Rittenhouse case and they've just read Twitter headlines, and that's what's poisoning their minds. If they just saw the facts of the case, surely there would be much more agreement. Now, I've said that a lot, but let me be clear. I think that you could know everything that I know, and there might still be arguments where it's like, I still don't believe this is self-defense. He went to a protest that he knew could have violent outcomes. He brought a rifle, saying what? That if he got into a violent outcome, he would be allowed to indiscriminately kill people attacking him? That might invite more killing, right? That he invited that? I think you could still make those arguments. Now, I think they're very weak, but they are definitely weaker than he's like a hungry, bloodthirsty white nationalist showing up to indiscriminately fire 60 rounds into a fucking crowd, right? They're way different than that. But Pakman has watched this entire trial, and he's still so off on so many points, but he's watched it all. He's seen it all. He's not even reading an article. He's actually watched the whole trial. It's crazy to me. I don't know. Yeah, he was AFK all the time. Whatever. Hassan has strong words for fake leftists. I don't think I care about this. I hope he's okay. Frown, frown. Dude seriously needs a break for his mental health. Hassan has been going through some difficulties lately, so please let's show him some love. What are what are the difficulties? Just turn off comments and stop reading LSF. Every other part of your life is fine. You're not canceled on anything. None of your income is threatened. You're like, everything is... Jesus Christ. I don't know, man. Fuck. I remember it. I remember those days. Okay. His editor made this video. Hasanabi Positivity Week.
Wait, what? Not.
Hassan Positivity Week is less of a week and more of a state of mind. Okay. I don't care about this. Don't care about that. Tyler the Creator meme has never applied more to anyone than it's not. Yeah, maybe. I don't know. Haven't you said you're pretty unique in dealing with the hate you get online? Yeah, I am. Yeah, that's true, I guess. I guess it's a lot. It's crazy that when you're that high up, you can still get affected by like LSF trolls. Like, Jesus.
People think that everything that you have, you're born with. Just some things that you need to, it's a skin in the hone.
Hold on for wherever.
True. Last time posting this. What? Attorneys for the 18-year-old Rittenhouse also told the judge that contrary to what the state had claimed about the software they used. Oh, I heard about this too. Software they used being industry standard for blowing up pictures of court, despite the fact that it added pixels to the image, was not true. The AMP software manual actually, I've seen this, actually instructed users that blow-ups of photos should only be used for investigatory purposes and not submitted as evidence according to the lawyers. Now, they claimed this, and they say that they have a manual, I believe, of the AMP software that actually says this. I don't know if that's been submitted anywhere or what, but if that is true, oof, yikes. Oh yeah, that we just heard them say they found out about that manual thing, but that was after they submitted their motion. Yeah. By the way, about the looters and rioters meme, the judge said that it was okay to call specific people looters and arsonists only during closing statements and only if the defense proved they were looting and committing arson in the trial. The judge also allowed the prosecution to call Kyle a cold-blooded killer at the same time.
It's with the jury. What he can't do, one of the people who formerly worked in the district attorney's office, more than once I had to reprove him for telling a jury, calling the defendant a worthless excuse for a human being. That's out of line. But if he thinks that he is using a term that the person has earned by his behavior, I don't think I'm going to, in advance, restrain him from doing that. And it's not, I don't think it has anything to do with the rule that I have that does not permit the use of the word victim until that's been decided.
I respectfully disagree, Your Honor. I think it's the exact same issue. The terms that I'm identifying here, such as rioters, looters, arsonists, are as loaded, if not more loaded, than the term victim, Your Honor. And I've had many trials with you, Your Honor, where there has been evidence that a person has suffered some sort of injury at the hands of the defendant, and you have still not allowed me to call them a victim, even after the evidence has come in, because there's been no jury determination.
I don't think you're accurate about that. I am talking about the use of the term victim in regular discourse, not in final argument when you're arguing that the person was the victim of a crime. I think that
my recollection is different, Your Honor, but I think the overall point the court is concerned about is that we are labeling someone when ultimately it's the jury's call. We are labeling them before the jury makes their decision. And your concern with the term victim, as I understand it, is...
You mean to tell me that if you in final argument said to the jury, Kyle Rittenhouse is a cold-blooded killer, that would be... You don't think that you'd be allowed to do that?
I think I should be. I think I should be allowed to call people a victim, too.
Why can't he call the victim an arsonist if that's what he thinks he can prove?
Your Honor, I have practiced in most of the courts in this county, and other than you, as you rightly pointed out, the other judges do allow us to call people victims, even at the beginning in an opening statement. And I would like to be able to do that in your court, but you've made it clear to me that we can't. And I think your concern there is that it is a loaded term. We are telling the jury something when there's been no judicial determination of that. And I think that's your reason for prohibiting the use of that term. I disagree. I think the state should be allowed to use it. We have a statute called the Victims' Rights Law. We have a constitutional amendment protecting the rights of victims. Our office works very hard to protect the rights of people that are victims of crime. And we have a department called our Victim Witness Coordinator. So we use the term all the time. I use it all the time.
He's got like the extra DM manual for the for the rulings on this.
And I think it should be used all the time. My point in this motion, Your Honor, is twofold. One is it's a double standard, and you've indicated you don't agree with that. So I'm going to move to my second point, and which is part of another motion in limine here, which is my motion in limine number 3, which is also in dispute. And that is that on this particular evening, we've already heard characterizations of behavior by Mr. Rosenbaum that night, by Mr. Huber that night. I don't know if there's been a lot about Mr. Grosskreutz, but their behavior that night has nothing to do with this case unless it was witnessed by the defendant. This is going to be a case about self-defense. So we're going to talk about the defendant's state of mind. And you said earlier in this hearing, and I agree with you, his state of mind is the most important thing in this case. And if there are things he witnessed with his own eyes by Mr. Huber, Mr. Rosenbaum, Mr. Grosskreutz, I have no problem with that because it does go to his state of mind. But the defense wants to argue, for example, that Mr. Rosenbaum, we have a well-known video of him at the Ultimate gas station that evening saying certain inflammatory things to other people. There is no evidence that I'm aware of that the defendant witnessed that. He's probably seen the video since, but that particular night, he wasn't there, didn't see it, didn't hear it, didn't know anything about it. So why would that be relevant? If it is witnessed by the defendant, it goes to his state of mind. If it wasn't, it's another act. It is an other act because the only purpose of introducing it would be either for some legitimate purpose, like knowledge or intent or motive, or to show that Mr. Rosenbaum acted in conformity, that it's his character, which is impermissible. We don't allow that type of character evidence. So my motion limine number 3 asks this court to rule that anything that Mr. Rittenhouse didn't personally witness that night on behalf of the 3 individuals that I've named is not admissible. It needs to be the subject of an other acts motion, which none has been filed, and I think that would be denied anyway because I think it's character evidence and it's propensity evidence. It does not go to his state of mind. The defense has earlier argued in this case that Mr. Rosenbaum's state of mind is somehow relevant to the reckless charge here. That is illogical. There is no connection whatsoever. Mr. Rittenhouse may have acted recklessly based on what he observed. He may have not acted recklessly based on what he observed. We've talked earlier about the jury instruction on recklessness. It talks about his circumstances. It talks about his state of mind. It does not talk about things that happened elsewhere that he didn't witness by other people. That cannot be relevant to the reckless charge. And it certainly isn't relevant to self-defense. He can't argue self-defense against things he's not aware of. So these other acts are strictly designed to attack the reputation of these individuals. It's designed to paint them in the worst possible light, to prejudice them.
There are people who can transcribe this as fast? Oh, I have this set to higher speed, sorry.
Can't defend themselves, Mr. Rosenbaum and Mr. Huber, because the defendant killed them. And it's unduly prejudicial to the jury to be told about any of those things, because the risk here, Your Honor, and this goes right back to the motion that we argued with regard to Mr. Rosenbaum, where the defense was seeking to introduce evidence that he was a sex offender. This runs the risk that the jury is going to decide that it's okay to kill Mr. Rosenbaum because he was convicted of a sex offense 15 years ago. Or it's okay to kill Mr. Rosenbaum because earlier that night in a separate location, he might have been involved in some sort of disorderly activity, started a fire, started using racial slurs, challenged people to a fight. None of those things were witnessed by Mr. Rittenhouse. So it has no bearing on his state of mind or his self-defense.
I feel like this is a really fair argument from the prosecution. I don't know how the judge responds to this.
So as I said in my motion, Your Honor, and this pertains also to my first motion limine when we talk about rioters, looters, or arsonists, the only evidence that the defense can introduce to establish that one of these people might have been a rioter or a looter or an arsonist is evidence that was not witnessed by Mr. Rittenhouse. So again, if he didn't witness it, it should not be admissible.
Thank you. Who's going on? Mr.
Judge, do you need me to address number...
Wait, does he not respond? Do we not get a response at all to that? Or...
one and all on the rioter thing, or are we good on that? Because I'm happy to show you...
It's a convincing argument, but wrong? Why is it a convincing argument, but wrong? Oh, the defense gets to respond. Sorry, okay.
Our good faith basis for belief...
So as I said, if he comes up with the evidence that he thinks supports a finding that the defendant is guilty on the homicide charges, then I'm not going to stop him if he, even over your objection, if he calls him a cold-blooded killer.
Understood.
Even if if he presents evidence from which a jury could find that, then that's a perfectly acceptable argument. And from the defense standpoint, if you present evidence that these people were engaged in lawless behavior or unlawful behavior or violent behavior, then I would let you use descriptive terms in your argument.
Okay, so I'll leave that.
Oh, you don't need to talk about it.
Okay, very good. So dealing with...
That sounds fair. I think I would lean actually towards the prosecutor argument on that, though, or the prosecution's argument. So he's saying that if you want to call somebody rioters, looters, or arsonists, you have to prove that they were first, or at least present evidence that they were. The prosecution argues though that like, hold on, it's not enough to say that they were rooters. It's not enough to say they were looters, rioters, or arsonists. You need to show that Kyle himself witnessed them looting, rioting, or committing arson. I don't think arsoning is a verb. And if he doesn't see it, then that can't go towards his state of mind or interaction with them, because it's not like he knew that Rosenbaum had said something in another video where he wasn't present or whatever. That would have no bearing on Kyle's state of mind right now.
Motion in limine number 3. I've kind of plowed this field already. So the idea behind some of these charges deal with all of the facts and circumstances going on that evening. I understand.
Wouldn't it be sufficient for the defense to support that Kyle believed they were rioters and looters? I'm not sure. I don't know. Maybe.
And because it doesn't help Mr. Binger when we talk about what happened that entire night. It's the behavior of many people there.
Couldn't the state of mind of Rosenbaum be of importance, though? Evidentiary standards are very complicated. I don't know all this, but I think character evidence has to show like a direct relation to what you're doing. It can't be unrelated shit. So like, don't quote me on any of this, okay? Because I could be totally wrong. But I don't think that if I were to set on fire like 3 dumpsters and then I were to go to try to stab somebody, you couldn't show evidence, I think, of me. Well, look, you just set 3 dumpsters on fire. Now he tried to stab somebody. I don't think you can say that. But if I tried to stab 3 people and then I run in and try to stab a 4th person, I think you can bring up, well, look, you just tried to stab 3 other people. I think you can do that. But it has to be like in the same wheelhouse, I think, to be allowed as like character evidence or something. I believe that's the case.
Was lawless. Mr. Rosenbaum is at the top of that list. But all of that lawlessness, all of the facts and circumstances surrounding what is going on is relevant in terms of Kyle Rittenhouse's conduct. I think it's impossible to say that it's not. And for him to limit and say what happened that evening, it's the same course of conduct. That's like me saying what I said to you 10 seconds earlier is other acts, because I'm not saying it right now. It's one course of conduct that happened. Mr. Rosenbaum never left. Mr. Grosskreutz never left. Mr. Huber never left. And Mr. Rittenhouse never left. They're all there the entire night. And this is what's going on. Mr. Rosenbaum is walking around with weapons. He's threatening people. He's threatening to kill people. He's starting fires. He's pushing lit dumpsters toward gas stations. All of that stuff.
It might also be, somebody in chat just said this in DGG chat, it might be the case, though, that there are different evidentiary rules for witnesses or complaining witnesses versus the defendant themselves. Maybe you can submit that kind of character evidence for like a complaining witness or for another witness, but you can't do it for a defendant. There might be different like standards there as well. I'm not sure. I don't know.
It's part and parcel of the facts and circumstances under the totality of the circumstances. It is not. We're not asking that there be McMorris evidence admitted of things that Kyle's aware of that he's done in the past. But to say this whole case comes down to those 3 minutes in a vacuum, without taking everything else that is going on, it's illogical based on the case. So it's not other acts evidence. It's the course of conduct through the evening. And because he's charged it the way that he's charged it, like the prior ruling on number 5, his state of mind, what is happening, all of those things are relevant. We don't have a peaceful protest. The lead detective in this case called it the most chaotic night he's ever seen. Those kind of things set the stage for these charges and for Mr. Rittenhouse's conduct. It is all relevant as it relates to whether or not his behavior under those circumstances was reckless and or intentional. So it should all be admitted.
There are, and this was discussed by the Supreme Court in the state against Jackson, I think 7 years ago, 2014, Wisconsin 4. Of course, I always honor the Supreme Court and it's what it's saying, but I had a murder case about 20 years ago. Perhaps you've heard of it, state against Mark Jensen. And I made an evidentiary ruling here, and the DA appealed it, and it went to the Supreme Court, and it's been going to trial again next April, 20 years later, because the Supreme Court made unanimously reversed my evidentiary decision, and they've been told now that by the federal court that they were wrong in doing that the original ruling was a correct one. So I say that as a prelude, not that I'm always right, but I don't want to totally embrace the Supreme Court's discussion in that Jackson case, but it was beautiful in terms of its realization that there are 3 different rules at work here with this type of evidence, and there is an ancient rule, and I do mean ancient. I was just looking the other day at the Federal Advisory Committee's commentary on it over the years, And they talk about it being an ancient rule, and it's the only reason it was still being used is because it's ancient. But it is our rule, and you can look it up in McCormick 157 or at...
Let's go, Domi.
And it's codified under the Federal Rule 404, our Rule 904, subsection, what's our number on it? Well, the federal rule is subsection B, subsection. This is the commentary from the advisory committee. It says, in most jurisdictions today, the circumstantial use of character is rejected, but with important exceptions. An accused may introduce pertinent evidence of good character. Well, let's skip that one because it's not here. Subsection 2. An accused may introduce pertinent evidence of the character of the victim, and they do use the word victim, by the way, as in support of a claim of self-defense to a charge of homicide or consent in a case of rape. That's without reference to whether the defendant knew about it. It's not McMorris evidence, as is stated by the defense.
Is Dustin going to watch any of Nick Riccida's, I don't know how that guy's name is, coverage of the trial? He's consistently had a panel of other lawyers and some prosecutors on that trial. I've tried to look at some of their shit, but it seems like they have definitely a big right-wing lean. That might not be fair of me to say, but just from what I get that vibe, so I'm not as interested in that. Didn't Binger bring up Kyle's unadmitted Facebook post in front of the jury? But hard to believe that he didn't do that on purpose, right? I don't know if that ended up counting or not. I don't remember that part. I'm not sure. They admit that they're right-wing on the panel. Oh, we're all right-wing. Okay, never mind.